Good evening and welcome to the Tracy Show. I'm here to bring you an update on the case of Robert Brooks. I hope you all remember Robert Brooks was unalived in the infirmary at the Marcy Correctional Facility where the guards beat him to death. Yes, well, 4 guards have pleaded guilty in the beating death of inmate Robert Brooks in Central New York Prison. The 4 men are Nicholas Anzalone. He pleaded guilty to a first-degree manslaughter. He had been indicted for a second-degree murder, first-degree manslaughter, and a first-degree offering a false statement in a filing. Anthony Farina, he pleaded guilty to first-degree manslaughter. He had been indicted for second-degree murder and first-degree manslaughter. Sergeant Michael Mashaw, he pleaded guilty to second-degree manslaughter. He had been indicted for second-degree manslaughter. David Walters, he pleaded guilty to second-degree manslaughter. He had been indicted for second-degree manslaughter. Oneida County Court Judge Robert Bauer promised Anzalone and Farina 22 years in state prison in exchange for their guilty plea. They had faced 25 years to life in prison on the murder charge. Shaw, and Walters were promised 3 to 9 years in state prison in exchange for their guilty plea. They faced 3.5 to 15 years if convicted of second-degree manslaughter. 4 guards rejected plea deals in court Monday. David Kingsley, Nicholas Kiefer, Matthew Gallagher, and Michael Fisher. These are the charges they face. Gallagher, second-degree murder, first-degree manslaughter, and second-degree gang assault. Kiefer, second-degree murder, first-degree manslaughter, second-degree gang assault, and first-degree offering a false instrument for filing. Kingsley, second-degree murder and first-degree manslaughter. Fisher, second-degree manslaughter. This is the prison time they face if convicted. Second-degree murder, 25 years to life. First-degree manslaughter, up to 25 years. And second-degree manslaughter, 3 to 15 years. Kiefer was offered a 9-year sentence in exchange for a plea deal, but turned it down. He now faces the possibility of life in prison. The judge appeared surprised that he didn't take the deal and asked Kiefer if he was certain about his decision. When considering plea deals, Onondaga County District Attorney William Fitzpatrick said each defendant has good legal representation, and their attorneys have raised factors he hadn't previously considered, including details about their backgrounds. The Brooks family issued a statement after the guard pleaded guilty. Quote, "We are grateful that the special prosecutor obtained these significant plea agreements," said Robert Brooks Jr., the son of Robert Brooks Sr. "It is important to us to see my father's Killers publicly admit what they have done and face severe consequences. These pleas help us know that some measure of justice is served." James Ricks, a brother of Robert Brooks Sr., said the pleas help us know that some measure of justice is served. He said the family is eager to see the other guards held accountable at trial. 9 correction officers and a prison sergeant were charged in the fatal beating of Brooks. Multiple correction officers repeatedly punched and kicked Robert Brooks in the groin, abdomen, and face on December 9th in the infirmary at the Marcy Prison in Oneida County. He died hours later at Utica Hospital. The savage beating which prosecutors said was the final of 3 beatings of Brooks, was recorded on video by body cameras worn by 4 of the prison guards. None had turned on their cameras, but 30 minutes of video was passively recorded without audio. Fitzpatrick extended plea deals in late March to each of the correction officers. He was appointed a special prosecutor in early January after the state attorney general's office recused itself. Oneida County grand jurors voted to indict the guards after viewing evidence presented by Fitzpatrick's office. Brooks' death was ruled a homicide by the Onondaga County Medical Examiner's Office. The cause of death was compression of the neck and multiple blunt impact injuries, according to the autopsy report. Brooks' autopsy showed he suffered extensive bruising, a broken nose bone, and bleeding in his genital and neck. Brooks arrived at the Marcy prison at about 9 p.m. December 9th. 3 guards carried him face down by his hands and feet to an examine table in the prison infirmary. Guards soon began punching and hitting Brooks, at one point shoving him up against a window. One guard can be seen in body camera footage putting both hands around Brooks's neck and yanking him off the exam table. After the beating, Brooks was seen bloodied and stripped to his underwear. The Brooks family has filed a wrongful death lawsuit in federal court claiming state officials oversee a dangerously broken prison system that brutalizes inmates. After the death, Governor Kathy Hochul named a new superintendent for the facility. She also announced a variety of prison reforms. Hochul has ordered 18 state employees involved in the beating to be fired. Several have resigned. Several of the correction officers are defendants in lawsuits alleging other cases of abuse against inmates, including one contending the Marcy prison has a beat-up squad. Brooks, originally of Greece in Monroe County, was sentenced in 2017 to 12 years in prison on a first-degree assault charge. He was arrested after stabbing his girlfriend multiple times. He had been scheduled for a parole hearing next year. Please listen and watch now, as you will see the officers take their plea deals or reject their plea deals. And in the meantime, in between time, don't forget to like the video, share the video, and subscribe to the channel. Subscribe to The Tracy Show. Thank you.
We start with breaking news and with a story that has made national headlines just 2 weeks before their trials. 4 of the Marcy prison guards taking plea deals. They will now spend years behind bars for their role in killing an inmate back in December. News Channel 9's Andrew Donovan is live in Utica. He has been tracking this case from the start. Andrew, fill us in.
Ryan, just like that, a trial where 8 defendants would have faced a jury, that's now down to 4 defendants taking that right, but 4 others decided that it wasn't worth the risk, knowing they could admit guilt today for less prison time and really get this over with now without facing even worse penalty. And that's what we saw unfold in Oneida County Court today. All 8 appeared preparing for a final pre-trial hearing, but instead, Nicholas Anzalone, Anthony Farina, David Walters, and Matthew Mayshaw each decided admitting guilt now to lesser charges and reduced prison time than what would be against them at trial was the better deal. Anzalone and Farina each facing life in prison if convicted of murder by a jury. So instead of life in prison, they took 22 years in prison with this decision.
No one's ever accused me of making generous offers. These people that pled today, this was This was a somber day. Those people's lives are over. I don't care if they were on the 2 1/3 to 7 range or the 22 range. Their lives are never going to be the same. Justifiably so.
That leaves 4 people headed to trial 2 weeks from today. It will still be a historic trial. 4 defendants is a lot. That's 4 defense attorneys, juries hearing from all of them, witnesses, evidence. That starts 2 weeks from today with jury selection, Ryan.
Okay, thank you so much. Andrew tracking it on for us. Have much more beginning at first at 4. Thank you so much.
The matter of the people against Nicholas Anzalone, indictment 25035. This matter is on for a final pretrial conference today, with the defendant's jury trial scheduled to begin 2 weeks from today. It is my understanding, however, that the parties may now have arrived at an agreed upon disposition, and I'll state my understanding of that proposal. That the defendant will be pleading guilty to count 2 of the indictment, charging the felony offense of manslaughter in the first degree, and the agreed upon sentence would then be 22 years in state prison, along with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges that would satisfy the remaining counts contained in the indictment. Is that the people's understanding?
It is, Your Honor.
Mrs. Franco, that's your understanding? Yes, Your Honor. Mr. Anzalone, is that your understanding of the proposal, and is that what you want to do here today?
Yes, Your Honor.
Please raise your right hand. You now swear you will tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
You may put your hand down. So, Mr. Anzalone, I'm going to ask you some questions now. These are to help me decide if I can accept your plea. If at any time you do not hear a question, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay?
Yes, sir.
Do you understand by answering my questions and pleading guilty here this morning, you're giving up your right to remain silent and to not incriminate yourself?
Yes, sir.
Have you spoken with your attorney about your case, about pleading guilty and thereby waiving your right to have a trial?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
Have you had enough time to speak with your attorney about your case?
Yes, sir.
The charge order to plead guilty to pursuant to this agreement is count 2 of the indictment, charging a felony offense, manslaughter in the first degree, which is in violation of Penal Law Section 125.20, Subdivision 1 and 20.00. The truth, the whole truth, nothing but the truth, so help you God. You may put your hand down. Mr. Freeman, I have questions for you now to help you decide if I can accept your plea. If at any time you do not hear a question, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay? You understand by answering my questions and pleading guilty here this morning, you're giving up your right to remain silent and to not incriminate yourself.
Yes, sir.
You've spoken with your attorney about your case, about pleading guilty and thereby waiving your right to have a trial.
Yes, sir.
Are you satisfied with the services of your attorney?
I am,
Have you had enough time to speak with your attorney about your case?
I am,
The charge order to plead guilty to pursuant to this agreement is count 2 of the indictment, charging a felony offense, manslaughter in the first degree in violation of Penal Law Sections 125.20, Subdivision 1 and 20.00. Here it is alleged that on or about December 9th, 2024, in the town of Marcy, County of Oneida, acting in concert with your co-defendants, fellow correction officers, intending to cause serious physical injury to another person, you did cause the death of that person. Specifically, you and your co-defendants participated in the multiple beatings of incarcerated individual Robert Brooks, which resulted in his death. Do you admit that to be true?
yes, sir.
Did you want anything further, Mr. Statute?
No, Your Honor.
Good morning. People against David Kingsley under Section 25025. This matter is on for a final pretrial conference with the defense jury trial scheduled to begin 2 weeks from today's date. Before I get to the final pretrial matters, it is the court's understanding that there have been further and ongoing conversations between the parties that a revised offer was awaiting. My understanding of what was proposed is a plea of guilty to count 2, felony offense of manslaughter in the first degree, with a recommended sentence of 22 years in state prison with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges. Is that your understanding, Mr. English, of what you've discussed with your client?
Yes, Your Honor.
So we should proceed to that.
Just reject the offer.
Mr. Kingsley, you've heard the terms of the proposed agreement, correct?
Yes, sir.
I believe we've talked about this before, but you understand that you do stand charged with a higher offense, murder in the second degree, such that if you're convicted after a trial of this matter of that higher offense, the law leaves me no option but to impose a life sentence. You understand that?
Yes, sir.
Understanding your exposure, you will not see an offer that's favorable again as we go forward. To the contrary, I will not accept any pleas but to the entirety of the indictment with no promises as to sentence. I want to turn down that offer with certainty of 22 today.
Yes, sir.
Or your Honor's got it, Mr.
Morning.
Again, could I get you, Mr. Bush, just a moment, please?
Matthew Gallagher.
Matters on for the final pre-trial conference, however, it's the court's understanding that the parties may have now arrived at an agreed upon disposition. I will state my understanding of that proposal. That is that the defendant will be pleading guilty to count 4 of the indictment, charging the felony offense, manslaughter, second degree. The agreed upon sentence will then be 3 to 9 years in state prison, along with the imposition of mandatory state surcharges. Is that the people's understanding?
It is, Your Honor.
And Mr. Capazza, is that your understanding?
Yes, Your Honor.
Mr. Mashaw, is that your understanding of the proposal, and is that what you want to do here today?
Yes, Your Honor.
Please raise your right hand. You know, swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do, Your Honor.
You may put your hand down.
Respectfully, Your Honor, if I can add, he is not waiving appeal.
Yes, that is part of the understanding. I'll ask you, Mr. Professor, just step just a bit to the side to let your client step up so that he can be heard clearly through the microphone. Mr. Mashaw, I have questions for you now to help you decide if I can accept your plea. If at any time you do not hear a question, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay?
Yes, Your Honor.
You understand by answering my questions that pleading guilty here this morning, you're giving up your right to remain silent and to not incriminate yourself.
Yes, Your Honor.
You've spoken with your attorney about your case, about pleading guilty, and thereby waiving your right to have a trial.
Yes, Your Honor.
You're satisfied with the services of your attorney.
Yes, Your Honor.
Have you had enough time to speak with your attorney about your case?
Yes, Your Honor.
The charge you are plead guilty to pursuant to this agreement is count 4 of the indictment, charging the felony offense, manslaughter, second degree, in violation of penal law sections 125.15, subdivision 1, and 20.00. It is alleged here that on or about December 9, 2024, while in the town of Marcy, County of Oneida, you did recklessly cause the death of Robert Brooks, specifically yourself, for a significant period of time during the beating of Robert Brooks, was the ranking corrections officer in the infirmary emergency room. Being aware of the risk that the beating by other corrections officers could result in the death of Robert Brooks and having a duty to intervene, you did not order the beatings to cease and delayed ordering timely medical assistance for the deceased, Robert Brooks, until it was too late to save him. Do you admit that to be true?
Yes, Your Honor.
Do you want anything further, counsel?
Judge, I discussed very briefly with Mr. Capazza. I have in my hand a form dated June 4th, 2024. They were trained and supervised by docs on their duties, including the duty to intervene as outlined.
However, I know there have been some continuing discussions between the parties about a possible resolution. How does your client wish to proceed today, Mr. Weissman?
Your Honor, just to formalize what just occurred, the people had a formal offer this morning. I pleaded 2 1/3 to 7 with no waiver of appeal, and we're formally rejecting that offer and we're ready to go forward to trial.
you said you're rejecting.
Rejecting and ready before the trial.
Mr. Fisher, let me just go over that with you. What the people have proposed is that if you pled guilty to count 5, the felony offense, manslaughter in the second degree, they're recommending a sentence of 2 1/3 to 7 years in state prison, along with mandatory state surcharges. As I understand it, they would not be requiring a waiver of appeal in this particular instance, such that you would be able to challenge the validity of that conviction before a higher court. If you're convicted after trial of the same offense, you face as much as 5 to 15 years in state prison. Understanding your exposure, you will not see an offer that's favorable again as we go forward. You want to reject that offer today?
Yes.
I'd like the offer then as rejected. The proposal would be that the defendant plead guilty to 1 count of felony offense of gang assault in the second degree. The agreed upon sentence would then be 9 years in state prison, with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges. What's your client's position with respect to that, Mr. Longren?
Your Honor, that was the last offer that was extended. I've reviewed that with my client, together with the potential downside of going forward. My client has rejected that offer, Your Honor.
Mr. Kiefer, let me just go over this with you to make sure you understand, sir. You discussed with your attorney the evidence that the prosecution has against you, correct?
Yes, sir.
You understand that what the prosecution has offered is, in fact, a lesser charge than the highest charge against you in the indictment.
Yes, sir.
They're proposing that you plead guilty to gang assault in the second degree with a 9-year sentence. If you were convicted just of that charge, you're facing 15 years in state prison. But you also have a much higher charge. You're charged with murder in the second degree here, for which the law would permit me no alternative but to sentence you to life in prison if you're convicted after trial of that offense. Understanding your exposure is life, you want to turn down the offer of 9 today.
Yes, sir.
That's in full consultation with your attorney, and you know what you're doing.
Yes, sir.
Back on the record in the matter of the people against Matthew Gallagher, under Indictment 25035. This matter is on for a final pretrial conference today. I know there have been some continuing discussions between the parties. How did your client wish to proceed today?
I'm prepared to proceed on without accepting the plea.
Let me just go over that to make sure you understand, Mr. Gallagher. What the people had proposed is that if you pled guilty to 1 count of the felony offense of gang assault in the second degree, they're recommending a sentence of 10 years in state prison, along with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges. If you're convicted after trial, you are charged with a higher offense, murder in the second degree, for which the law requires a sentence of life be imposed. Understanding your exposure, you will not see an offer this favorable again now as we go forward. You want to reject that offer of 10 years? Mark that offer then as rejected. Proceed with the final pretrial.
Recall David Walters.
This is the matter of people against David Walters, Indictment 25035. This matter is on for a final pretrial conference this morning. However, it's the court's understanding that someone revised proposed disposition had been extended. How does your client wish to proceed with respect to that, Mr. Peslock?
After lengthy discussion with myself and his family, it's my understanding that Mr. Walters wishes to proceed forward in accepting the people's amended offer as presented this morning.
Let me state my complete understanding of what's been proposed. That would be a plea of guilty to count 6, that is the felony offense of manslaughter in the second degree. The agreed upon sentence would then be 2 1/3 to 7 years in state prison, along with mandatory state surcharges. However, neither the court nor the prosecution will be requiring a waiver of appeal in this instance. Is that people's understanding?
It is, Your Honor.
Mr. Passalak, what is your understanding?
It is.
Mr. Walters, is that your understanding of the proposal to resolve these charges? Is that what you want to do here today? Please raise your right hand. I swear you will tell the truth, the whole truth, nothing but the truth, so help you God. You may put your hand down. Mr. Walters, I'm going to ask you some questions now. This will help you decide if I can accept your plea. If at any time you do not hear questions, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay? You understand by answering my questions and pleading guilty here this morning, you're giving up your right to remain silent and to not incriminate yourself. Have you spoken with your attorney about your case, about pleading guilty and thereby waiving your right to have a trial? Are you satisfied with the services of your attorney? Have you had enough time to speak with your attorney about your case? The charge you are to plead guilty to pursuant to this agreement is count 6, charging you with the felony offense of manslaughter in the second degree in violation of Penal Law Section 125.15, Subdivision 1 and 20.00. It is alleged here that on or about December 9, 2024, in the town of Marcy, County of Oneida, you did recklessly cause the death of Robert Brooks. Specifically, you were present in the infirmary and in the emergency room and had a clear opportunity to witness the beating of Robert Brooks and was aware of the risk that the beating by other corrections officers could result in the death of Robert Brooks. Having a duty to intervene, you did not in any way attempt to stop the beating and did not in any way attempt to shield Robert Brooks from the onslaught. In addition, while an infirmary nurse attempted to enter the emergency room to attend to Mr. Brooks, you verbally instructed the nurse not to enter the emergency room. Is that true?
Yes, sir.
Did you want anything further, Mr. Fitzpatrick?
Just as I did with Mr. Nash, Mr. Paslock, I'm going to hand you a form dated July 29, 2024, and what it is a DOC's training acknowledgement form regarding various weapons that they are entitled to use, as well as use of force, which includes a duty to intervene.
Mental problems that could prevent you from understanding what you're doing here today. Did you consume any kind of drug, medicine, or alcohol before coming to court that could affect your understanding? You're not currently on probation or parole, correct? By pleading guilty, you're giving up your right to have a jury trial. Do you understand that? At a jury trial, you would be presumed innocent and you would be entitled to the following rights: to be represented by your attorney, to confront and cross-examine witnesses presented by the government. You'd have the right to remain silent and not incriminate yourself. You would have the right, but would not be required, to call witnesses, or you could testify on your own behalf. You would also have the right to require the government to prove your guilt beyond a reasonable doubt. To a jury of 12 people, it would have to be unanimous in finding you guilty. You understand you have each of these rights, and by pleading guilty here today, you're giving up each of these rights. You understand by pleading guilty, you're also giving up any defense you might have to these charges. Now, a plea of guilty is the same as a verdict of guilty rendered by a jury after a trial. Do you understand that? Other than the plea and sentence agreement I spoke of earlier, has anyone made any other promises to get you to plead guilty? Did anyone threaten you or force you to plead guilty? Have you entered this plea today voluntarily and of your own choice? You understand while you're incarcerated for this felony conviction, you will not be able to vote in an election until such time as you are released. Based upon the defendant's statements and his demeanor here in court, I find a knowing voluntary plea with a factual basis. I will direct the clerk to enter the plea in the minutes of this court. You will adjourn the sentence until
November 21st.
November 21st, 9:30 a.m. for sentencing. Does Mr. Walters wish to remain on pending sentence?
Yes, please, Your Honor.
All right, Mr. Walters, I'll permit that based on the bond that you previously posted to the court. However, I'm attaching 3 conditions as part of our plea agreement. Condition 1 is you have to meet and cooperate with probation as they prepare you